crowd in here following on from our first session, so thank you for those who stayed with us. I can see a few faces who were in the first session, and also thank you for everyone else who's joined us. My name's Ben Fisher. I'm Head of External Communications at the Solicitors Regulation Authority. Just a couple of things before we start the session. One, this session is being live streamed. There's a camera over there. So if you want to watch the session, you can watch it either on our Twitter account or on YouTube. And what that also means is that you can watch it after the session on playback. So the slides will be up there. You can watch it on playback. So either if you have somewhere else to run off to, or you want to watch one of our later sessions, they'll all be on there. So this session is around our new standards and regulations, which we've now announced the date of when they come into effect, which is the 25th of November, which is a very important date because it's not only my mother's birthday, but it is when 4 years worth of work from the SRA comes to fruition. And Chris is going to talk about that. Just to introduce Chris, Chris is our Director of Regulatory Policy. He's got more than 15 years experience in the legal services sector and has been at the SRA for 4 or 5 years now, and previously was working at the Legal Services Board. So I'll hand over to Chris, but the one thing I'd just finally like to say is there will be some time for questions at the end, so please make sure we get some questions at the end. We want to hear what you think, what's bothering you, or where you have queries, but also we're just in the stand over there, so if there's anything that you haven't covered, just come and catch Chris or one of us guys afterwards. So thank you.
Thanks very much, Ben. Thanks for coming, everyone. It's not very often I have to compete with supercars for an audience, but I'm doing okay so far. I'm going to talk about our new standards and regulations. I think as most of you are here, you're probably interested in innovation and opportunities to do things differently. We think our approach to regulation really supports innovation and helps you to deliver services and do things in the way that you want to do, that works for you. Which is obviously good for you and also good for helping people to access legal services in different ways. Right, let me see if I can work out the slides. Okay, so let me start by giving you a little bit of context about the sector that we regulate. First of all, diverse and growing sector. It's worth about £30 billion every year. It's really big. We regulate a record 146,000 practicing solicitors, more than we've seen before. Good chunk of those work in-house. We have about 10,500 law firms, around 700, so over 1 in 20 are now alternative business structures, which means that they have non-lawyer owners, managers, or investors. The firms range from single solicitor firms to huge global firms. And we are seeing a lot of innovation in the sector, in the market, with new service delivery models, structures, and processes. So just to give you a few examples, the sort of things that we're seeing different pricing models with things like fixed fees on the app. More and more online and digital services, no real surprise there. More unbundled services where the client does part of the work on a case and the lawyer will do part of the work on a case. More subscription services where people pay a certain amount of money for a set amount of legal services. We're seeing more and more kind of flexible working, people not working from a traditional law firm, a traditional office, and things like virtual offices where there's a facility for doing all the backroom work, conflict checks, etc., but the lawyers aren't all sat together. We're also seeing things like people using lawyers and paralegals on a as and when needed basis. So what's driving this innovation? Well, people tell us it's all sorts of different things. So demands of clients being an obvious one, or potential clients. Just new ideas and new money coming into the sector as restrictions around who can own and manage law firms have changed. Technological advancements, a big one. You'll see plenty of that here today. And of course, competition. And this includes from beyond the regulated sector. Some research now suggests that around 25% of all legal services are delivered outside of regulated law firms. And of course, firms just wanting to be more efficient, grow their business, keep their workforce happy, etc. So a growing, diverse market, lots of people access legal services, very happy with the service they get, but there are some real challenges too. One of them being that only a very small number of individuals and small businesses that have a legal problem go to a lawyer to help them with that problem. And they find it very hard to choose between different types of provider. So some real challenges there as well. Okay, in that context, I'll talk a little bit about some of our priorities and some of the things that we've been changing. So, first of all, we have a clear focus on high professional standards. Regulating solicitors and law firms, that's always going to be at the core of what we want and what we do. Beyond that, we want to be a proportionate and targeted regulator, underpinned by a proportionate and targeted rulebook. So this means stripping away unnecessary rules to make it easier for solicitors, for law firms to work in different ways, to give you flexibility to organise yourselves and deliver services in ways that work for you, clients and prospective clients. We will step in when we think there's problems that need addressing, and the previous session here today was around some of our work on requiring more transparency, particularly around pricing, which we think will really benefit consumers of legal services. We want to make sure that everyone's trained to the same high standard, and in 2021 we'll be introducing the single examination for qualifying solicitors to make sure everyone is tested to the same standard. And I think there's a session on that here tomorrow. So we'll keep an eye on developments, technological developments, to try and find the opportunities and support the opportunities. We're all for firms finding different ways to deliver services using technology to improve their service and make things work better for them. As a regulator, we also need to be aware of some of the risks that might be coming through that as well. And we also want to make sure that there's appropriate public protection when things go wrong. So that means having things like the right professional indemnity insurance requirements in place, having a compensation fund that's viable and can help those that really need it when they've suffered a loss. And also making sure that when things do go wrong, we have the right enforcement approach to protecting the public and dealing with those issues. So let me move on and talk about our handbook review. How many of you here are familiar with our handbook now? Is it something that you're into the detail of on a regular basis? Okay, so quite a few of you. Well, we've reviewed and redrafted the whole of our handbook, the whole of our rule book, all 450 odd pages of it, all 20 odd sets of rules. We've consulted several times. We've been working on this for about 4 years, spoken to thousands of people, thousands of solicitors, and we know that there were some things that we could improve. The current handbook is too long, we think, too complex, can be difficult to use and navigate, and because of the level of detail in it, it's really hard to keep up with the changing world. We're on version 20-something since it was introduced in 2011. So it has that real sort of prescription, that real detail that can be seen as us trying to micromanage how firms do their business, which isn't what we want to be doing. So we're replacing the existing handbook. As Ben mentioned in his introduction, we'll have our new standards and regulations coming into force on the 25th of November this year. The new standards and regulations will look very different from the existing handbook. We've removed all unnecessary rules, prescriptions and restrictions, including about how and where solicitors can deliver services. So our aim is to have some very, very clear standards, but not telling people how they must meet those standards. So trusting professional judgment more. They'll be a lot shorter. So say current handbook about 450 pages. The new standards and regulations will come in at around 130 pages. So real difference there. we think they'll be a lot easier to use than the existing handbook. We've really tried to make sure that things are grouped together in an easy-to-use way and are very clear. I'll talk about this in a bit later, but we also will provide support, guidance, and toolkits in areas where people have told us they think they most need it, particularly as they transition through to this new look standards and regulations. So let me get into the detail of some of the key changes a little bit now. So first of all, our principles. So the principles are fundamentally about ethics, how we expect everyone we regulate to act. Firms, solicitors, managers, employees. So if in doubt when faced with a particular situation, principles are usually the right place to start. So we haven't made major changes to the principles, but we have reduced the number of them. At the moment we have 10 principles. We will have 7 going forward. And what we've done is we've removed some of the principles and put them in the code where we think that those things are practice specific and don't need to be in the principles. So things like dealing with your regulator and ombudsman in an open, timely and cooperative manner. We don't think that's one of those overarching principles, although still really important. We have a principle around acting in the best interest of clients. We also currently have one around providing a proper standard of service. We don't think we need those both in the principles, so proper standard of service meets the code. Still really important, still need to be met. So moving on to the codes of conduct, there are some big changes here. At the moment we have a single code of conduct, a long code of conduct that applies to anyone. It just says you. So does you mean solicitor? Does it mean firm? What does that mean? We've tried to clarify this by having 2 separate codes of conduct. One short, simple code for solicitors, every solicitor, whoever they are, and wherever they practice, and a separate code of conduct for firms, which is more about running the business. One of the drivers for this is we want every solicitor to understand that code, those standards apply to them, and to familiarise themselves with the code. At the moment, we know that lots of in-house solicitors don't engage with the code because they think it's something around running a law firm. And we also know that lots of law firms that have, lots of solicitors within law firms that have some big compliance departments, they consider that to be something for the compliance department. So by having this short code, we hope to put some of those misconceptions right. We've also removed indicative behaviours from our code. At the moment, we have non-mandatory indicative behaviours sitting alongside the requirements of the code. We've changed that. So if you have to do something, it will be in the code in future. If it's guidance, it will be in guidance, and if it's not needed, it won't be there. Okay, the other big area where we've made changes is around our authorisation rules. We've split those again by individual and by firm. And we've got rid of anything here that we think is unnecessary again, so stripping away some of that bureaucracy. A good example of that is at the moment, if you are an approved person as having a position in one firm, if you move firm or move position, then you will have to be approved again. We don't think that's necessary, so we've got rid of that requirement. Okay, let me move on to the accounts rules. So accounts rules are another area where we've made some really significant changes, and really I think exemplifies what we're trying to achieve with the review of the handbook and the new standards and regulations. At the moment, accounts rules are 40-odd pages long. They are very, very prescriptive, telling firms how they need to run their accounts department in effect. So we have been through and redrafted those rules and really focused on what's important around having accounts rules, and that's around keeping client money safe and keeping it separate. So we've got rid of things like saying that you have to pay a check in within 48 days of receiving it. I mean, what makes that the right number? And that can be really, really difficult, particularly for firms in rural areas. So in future, we'll say things like you have to do things promptly, and then trust the firm's judgment more about what that means, and it may be different in different circumstances. In the past, we know from the accountants' reports we get in that of firms that hold client money, about 50% are in breach of our current rules at any one time. But actually, the impact that has on clients, because their technical breaches are very, very small, well, in fact, non-existent, so we don't take any action. So what's the point of having all those detailed and prescriptive rules that are really hard to comply with, where if you breach most of them, it doesn't really have an impact? So we've really changed that approach, so we focus on what's important and try to remove all of that real detail and prescription. We obviously do still have some detail in there, so need to return client money as soon as it's no longer need to keep it. Firms are still expected to keep good records and reconcile accounts every 5 weeks, just some examples. Another thing that we really emphasize in our new accounts rules is that firms have the option of using third-party managed accounts, so escrow type arrangements regulated by the Financial Conduct Authority, as an alternative to holding client money in their own accounts. That's an option that's open to them. We've highlighted that, and I know that there's some third-party managed account providers exhibiting here over the next couple of days. Accounts rules, because we've made such big changes, then it will be an area where we will have quite a lot of guidance initially, and we hope to start pushing some of that out next month. Okay, so let's move on to practicing flexibility. This is one of the really big changes will be a big change in the new world. We're given qualified solicitors bound by the code of conduct that we oversee and regulate, greater flexibility about how and where they can practice. There are two main parts to this. The first is solicitors being able to offer reserved services to the public as freelance solicitors. So this means if you're a solicitor who works on your own as an individual, at the moment you also have to be authorised by the SRA as a firm, in effect, as a recognised sole practice. Going forward, we'll be saying you don't have to do that. If you're genuinely working on your own, you can do that under your personal authorisation under the practising certificate. So what do we mean as working as an individual? It means things like you don't have employees, you don't have partners. You're not engaging clients and working through a service company. You're engaged personally by the client. There are some restrictions. So freelance solicitors won't be able to hold client money other than payments on accounts and professional disbursements. They'll also have to have adequate and appropriate professional indemnity insurance. There will be access to the compensation fund for their clients. They must have been practicing for at least 3 years. So lots of reasons why people might want to do this. One of the common reasons that people talk to me about is, say, approaching retirement, you want to carry on working with some of your clients but not be within a firm, not run a firm. But there's lots of other opportunities there as well. The second big change is that we will allow solicitors to offer what are called non-reserved legal services to the public in legal service providers in businesses that we don't regulate. Does anyone know what the reserved legal activities are? No. This is what regulation in the Legal Services Act is built around, but knowledge of them is actually really, really low. It's a short list of legal activities that the law says, if undertaken by a solicitor, that the firm that they're working for, the business that they're working for, must also be authorised by the SRA or another legal regulator. So very short list. So litigation, some parts of the conveyancing process, making probate applications, rights of audience in some courts, administration of oaths, and there's one more, notarial activities. So that's it. So anybody who, whether solicitor or not, can set up shop and deliver any other legal services, can give legal advice without being authorised or regulated at the moment. And we've said that about 25% of legal services are currently delivered from unregulated businesses. So some of the common examples, you have will writing companies, you have HR companies that will also offer employment advice. At the moment, our rules stop qualified regulated solicitors from delivering legal advice to the public in those types of businesses because we don't also authorise the business. So anybody else can deliver services in them, just not qualified solicitors. We don't think that makes sense. We think it's better to have solicitors in those businesses. It will help drive up standards in them, and also it provides more opportunity for individuals and small businesses who aren't accessing businesses now to access services in different ways. So more opportunities for solicitors about where they can work, how they can practice, and more opportunities, more options for people to access legal services in different ways. So that will be allowed from the 25th of November. So I'd also just like to highlight that our approach to enforcement. When I'm out speaking to firms and solicitors about our new approach with less detail, with less prescription, one of the concerns that's quite often raised is, well, this gives the SRA quite a lot of discretion about what they consider to be right and wrong. So we've published our enforcement strategy, which makes it really, really clear what we think the purpose of enforcement action is and when we'll take enforcement action, what's serious and what isn't, what are mitigating and aggravating factors in a particular situation. So this is all set out in our enforcement strategy. We're also really, really clear that we will not be trying to second guess how solicitors, how firms have complied with our new standards and regulations. We've said that we'll trust judgment more, and that's what we mean. Also, to complement the enforcement strategy, we publish all of our internal decision-making guidance. So people can see what decision makers in the SRA are looking at when they're deciding what enforcement type action to take or whether to take action. We've also published and will continue to publish enforcement in practice topic guides. So where there's a particular grey area or particular salient issue, we'll put something out that says what our approach to enforcement might be in that situation. And for those that were here at the previous session talking about our transparency requirements, we've put one out about those transparency requirements and how we will approach enforcement. So if people are engaging and trying to comply, then we are unlikely to take enforcement action. We will help them come into compliance. But if firms are just not engaging at all or are being misleading in what they put out there, we're more likely to take a harder edge. So those sorts of guides are out there too, and we will get more of them. So what do we think those benefits and opportunities are? Well, first of all, our new standards and regulations will just be easier to understand, easier to use, and easier to navigate, and really give you that greater flexibility to run your businesses and deliver services in the way that you want to do. What this means is really up to the individual firms. It may mean a small change, for example, how you run your accounts department. It could mean that you want to totally change the way that you structure your firm and deliver services. Or you may decide to do absolutely nothing at all, or nothing fundamental because you're happy with what you do now and you want to focus on what you do well now. In the whole, it's really up to you how you take advantage of this flexibility. But I think there is a real opportunity to look at your firm and ask, are there things that you're only doing now because our rules tell you to, or things you're not doing now because our rules tell you they can't? And is that the way that you'd ideally work? You know, what do your clients want? What are your competitors doing? What are the opportunities for you to change the way that you do things, to be more efficient or to work better, to grow your firm, etc., etc. Our aim is really to give you flexibility to exercise your choices and try and support you in doing so. Also, there are real opportunities here for individual solicitors and aspiring solicitors to choose different career options. So there'll be opportunities to qualify and work in those different types of businesses. and also more opportunity for solicitors to work on their own. So some real opportunities for individuals. And we hope that our changes will make life easier, make things better for the public too. So more ways of delivering, more ways of accessing solicitors. And we hope that giving this flexibility will drive innovation in firms and will encourage them to try and tap into that currently underserved legal services, cohort of people not accessing services. So as I say, on the whole, the changes are around providing opportunities, not forcing you to change. But there are some things that you should be doing as a firm. So you should familiarise yourself with the new standards and regulations to understand the changes. They're all published now, available on our website. Are staff and decision makers familiar with the new principles, codes, etc., and the new concepts within them, such as freelance solicitors? There's a cultural shift here with having less prescription and trusting judgment more. So are people aware of that? You need to be able to justify and record the rationale for why you make decisions, why you take actions in certain ways. We have our new digital badge, which again was covered in the previous session. That's available on a mandatory basis at the moment. In November, that will become compulsory when the new standards and regulations come in. So you'll have to make sure the digital badge is on your firm's website. And guidance at the bottom there, then we will be putting out guidance. So familiarise yourself with that. Do you have a mechanism in place to make sure you're keeping up with our guidance releases? Okay, so innovation is obviously a big theme of these couple of days here in this exhibition. So I really want to emphasize that you can innovate now. Our regulation doesn't stop people from innovating, from doing things differently, from using technology, from delivering services in different ways. We really support that and encourage that. So if you want to try and do something differently, whatever that is, don't assume you can't do it, that your regulator won't let you, because in most instances, it will be okay to do that, or we can help you understand how you can do that in light of regulation. Lots of things that we do now through what we call SRA Innovate. We offer guidance and support to people who are thinking about innovating around how they do that within our regulation. If authorisation is needed, we can help people through that authorisation process. We've got a really good authorisation team that will help with these sort of innovative ideas. Something we do fairly often is we can offer letters clarifying to potential investors or to insurers that what's being proposed is okay with the regulator. That can sometimes be a barrier with getting that investment or getting insurance, is just that assumption that this is going to be difficult because of the regulation. We can offer some help with that. We also have the facility, and we do offer waivers to our regulations if they're needed. So if you want to try something different and it isn't allowed under our rules, but we see there are benefits in what you're doing and there aren't really big risks, then we can waive those rules. And we also have something called the innovation space, where anything that's particularly innovative and new to the sort of sector and sort of how it fits regulation, then we can put that in a safe space and allow it to be piloted with certain conditions in place. Finally, I just want to highlight the Legal Access Challenge, which will come live later this year. We've won some government funding to help or to try and encourage firms, from tech companies, from law firms, to whoever it might be, to try and come up with technological solutions to access to justice issues. So we'll be running a competition later this year where there will be prize money available to help people develop those solutions, and also trying to develop a support network for those innovators that might be able to help with the access to justice issues. So more on that later this year. How are we doing for time? Okay. So just finally, I wanted to highlight all of the support that's out there now, all of the guidance that's out there now. So as I've said, with the new standards and regulations, we have committed to putting out guidance, toolkit, support. Our aim is to make it look very different, feel very different than some of the guidance you see now. We want to be really clear that we won't be introducing rules through the back door with this guidance. So we'll have things like case studies, so where we get real examples of people facing dilemmas, issues, challenges. We'll put case studies out there highlighting those and how they were resolved. It means we can keep updating that, and a good bank of material comes through to help people. We'll also look at doing things like checklists more, where we'll put out a checklist of questions that you should ask yourself when faced with a certain situation. But we won't tell you what the answer is to that. There probably isn't one right answer, but the questions that you should go through when faced with that problem. So that'll be coming out well in advance of the introduction of standards and regulations. We also have our professional ethics helpline, who really good resource for people faced with an issue. We publish a risk outlook, which is a really, really good document that sets out what we think the priority risks are in the sector in any one year, and what our approach to mitigating those risks are, and really helpful tips for solicitors and firms to deal with those risks themselves. We publish lots of research and reports. That's all available on our website. And finally, there's legal sector AML guidance. Anti-money laundering is a huge priority at the moment. There's a session on that later today, but there is support out there for you. Okay, so a whistle-stop tour through our new standards and regulations. I think we've got a good 15 minutes for questions, if anybody has any. And I have to remember to repeat the question before answering it because of the streaming. Hi. So the question there was that the standards and regulations still has some areas that haven't been approved by the Legal Services Board. Legal Services Board is our oversight regulator. They have to approve all of our new rules. We don't know. We can't predict what the Legal Services Board will say. But what we've done is we've published the standards and regulations, and at the front we've put a table of exactly what the status of those rules are. It's not the really big stuff that's going for approval, so you can work with what you've got now and have a pretty good idea of where we'll end up. There's just a few areas where there's still confirmation needed. Okay. Hello, yes. Sorry. So last year we consulted on proposed changes to our professional indemnity insurance requirements for authorised firms, and also for the compensation fund arrangements. So the question was whether we've shelved those proposed changes or whether they will be made. Well, the answer is that we will be making decision and responding to that consultation later this year. We had a lot of responses, lots with very strong views, and lots that actually offered some real constructive ideas of how we could reach the same goals a little bit differently. So we're just taking some time to go through all of those responses, consider all of the suggestions and the proposals made. So we will be responding later this year. We haven't just kicked it into long grass, and you'll hear no more about it. Any more questions? No? Okay, I will hang around until the session's due to end, so please do come and grab me if there's questions you want to ask, but not in front of the crowd. Thank you.